All right, let's get right into it. A federal court just gave the real estate industry a massive win, striking down a major anti-money laundering rule. But instead of popping champagne, a lot of legal experts are actually sounding the alarm. Today, we're going to break down why this victory could be a classic case of be careful what you wish for.
So how can a win actually be a loss? It seems kind of weird, right? On the one hand, a huge compliance headache for the industry has just vanished. But on the other, the celebration might be very, very short-lived. Let's dig into this paradox.
Okay, so first up, let's talk about the big news, the thing that brought a huge sigh of relief to title companies and real estate pros everywhere. A federal judge down in Texas has officially vacated a nationwide anti-money laundering rule from FinCEN. And just to be clear, this wasn't some minor regulation. This was a big one that affected a ton of transactions.
So what was this rule all about anyway? Basically, it forced people to report on any residential real estate sale that was an all-cash deal. Not financed with a typical loan, and was sold to an entity like an LLC or a trust. And here's the crucial part. There were absolutely no limits. It applied to a deal in small-town Ohio just the same as a multi-million-dollar deal in Manhattan.
So how did they win? Well, the lawsuit, which was brought by Flowers title companies, was successful because the court basically agreed with their main point. The judge said, whoa, hold on a second, FinCEN. You can't just paint every single one of these deals with the same suspicious brush. They just couldn't prove that these transactions were automatically suspicious enough to require this kind of sweeping nationwide reporting.
But here's where it all gets messy. This wasn't some simple, final decision that everyone can just move on from. The ruling in Texas doesn't exist in a vacuum, and honestly, it's just thrown the entire industry into a state of major legal confusion.
Now get this. This is what really throws a wrench in the works. We have two different federal courts looking at the exact same rule and coming to completely opposite conclusions. I mean, in Texas, the judge says the rule is gone. But in another case over in Florida, the court said the rule was perfectly fine. It's a classic legal showdown.
So this legal chaos, it creates a real vacuum. And if you want to know what that might look like, well, we've seen this movie before. Legal expert Jamie Schaefer points to the whole saga with the Corporate Transparency Act, where rulings just went back and forth, creating a total roller coaster for businesses. The real estate industry could be in for a very similar ride.
All right, so now we get to the absolute heart of the matter. That's surprising and frankly kind of scary warning for the industry. This is the part where what looks like a legal victory starts to feel more like a major strategic mistake.
In this quote right here, it says it all. This is from James Vivenzio, a partner at the law firm Perkins Coie. And listen, this isn't just some random lawyer's opinion. This is a guy who used to work for the government and actually helped write the law that gives FinCEN its power. So when he says, be careful what you ask for, you should probably listen.
Okay, so let's break it down. Why is this win so risky? Well, first off, the U.S. Treasury has been saying for years that real estate is a prime channel for money laundering. They're not just going to drop this. Second, FinCEN still has a ton of authority to regulate the industry. But here's the real kicker. That rule that just got tossed out, it was actually considered the light touch approach. FinCEN was taking it relatively easy. The real fear is what they might come back with next.
And what does tougher look like? Well, imagine this. Instead of just having to report one specific type of transaction, FinCEN could come back and require title and real estate firms to build out entire anti-money laundering programs from scratch. This would be a completely different ballgame, a massive operational lift with complex monitoring and filing suspicious activity reports or SARs, just like a bank has to do.
So, the rule is gone for now, but there's this monster of a regulation possibly lurking around the corner. If you're a professional in this space, what in the world are you supposed to do right now? How do you navigate this mess? Well, experts are basically saying hold your horses. The advice is to play it cautiously. First, all that work you did to get compliant, don't throw it in the trash. You might need it again, like tomorrow. Second, start building flexibility into your contract so you don't get caught flat-footed if the rule suddenly snaps back into effect. And finally, don't go making voluntary filings right now, but definitely stay ready for new guidance from FinCEN. And hey, if you're one of the people who already filed reports while this rule was active, there's some good news for you. Don't worry about any privacy lawsuits. You were simply following the law as it was written. In fact, you would have been breaking the law if you hadn't filed. So, you're protected. And all of this leaves us with one big, lingering question about what this ruling really means. The industry won the battle and got rid of a reporting headache. But in doing so, have they just opened the door to a much bigger, much more painful war on regulation? It just might be the ultimate be careful what you wish for scenario.